Hi there, good afternoon and good morning. Potentially for those of us joining us today in BC or in Alberta, I am Sephton Leibbrandt and I'm an associate at Samfiru Tumarkin LLP, and we are the employment lawyers. So thank you everybody for joining us again on our regular Q&As this afternoon, where we of course answer all your questions to do with employment law, ranging from severance packages and terminations, most importantly to, of course, human rights concerns and other serious issues, workplace difficulties, work environments, and things of that nature. Anything to do with employment law, any issues or concerns you're experiencing with your employment, those are where we answered that today in our regular installment. So again, thanks for joining us, everybody, this afternoon. So basically, while we kind of wait for some questions here to trickle in on the chat, a number of important kind of employment related news articles are around of late. For instance, my understanding is that Nike, for instance, is trimming back a significant number of their positions. I think there's also other companies where, for instance, AI, I think Salesforce is looking to remove a number of support roles because of use of AI in employment. And AI in employment is becoming, very, very substantial and significant, especially with respect to, job applications, people sending in job applications and never receiving any kind of response, to that application. There's going to be, for instance, legislation coming in the new year that's going to require that employers disclose when they post job applications any particular AI system that they are using to evaluate those applications. And then there's also going to be obligations for employers to respond. I think it's within 45 days after an interview to an employee that they have interviewed, of course. So to prevent, a lot of, again, the use of AI just to, dismiss a lot of applications and this kind of practice of ghost application that's happening a lot nowadays, where people, anybody tries to apply to some position and you never hear anything back whatsoever, and potentially not a person never even looked at your application. It was just some AI program that pre-screened it, and then depending on certain keywords that were or not mentioned, it may let you through the wall, or just completely reject your application outright. So that's going to be happening in the new year, which is a good step forward by the government in that respect, because this kind of great use of AI to screen applications, number one, and then just a lot of companies posting positions which don't even exist potentially, or they're not actually really intent on hiring for at a particular time, has just become absolutely outrageous in the marketplace, and far too prevalent. It seems that the vast majority of these job applications posted on very prominent sites like LinkedIn or Indeed nowadays, that half of them aren't actually real legitimate job opportunities. It's just a company potentially posting for the potential to hire someone at some future point, not with an actual position available. So that's not appropriate, certainly not fair to people who are looking for a job. And the unemployment rates right now are still very, very high in Ontario and throughout the rest of Canada. So it's good that at least in Ontario, the government's trying to take some action, albeit limited, to try to restrict this all too prevalent practice nowadays of just minimum effort on the part of employers to try to effectively screen and review applications and posting for positions that really may not exist anywhere in the company, which is quite absurd in circumstances. So that's going to be happening in the new year. They got to disclose those kinds of applications and use of AI going forward, which is good, so people can identify okay, is a person actually going to look at my job application, or is this going to be some program on the internet that's going to try to find some keywords here and there, and I hope that will influence the companies that people elect to apply to, and if there's enough potentially backlash that perhaps to some degree employers will start curtailing the use of AI and definitely the posting of these ghost positions online where they have no real intent of actually hiring anybody in the near future. So that's going to be happening again in the new year here, which is a good step forward because at the moment it's quite a crisis in that respect. So it looks like we're getting a bunch of questions rolling in here, which is fantastic. We're going to jump to the first kind of question now. Again, if you're just joining us, my name is Sephton Leibbrandt. I'm an associate at Samfiru Tumarkin LLP, and we are the employment lawyers. Thank you, everybody, for joining us this afternoon on our regular Q&A sessions. So it looks like Lynn from YouTube has asked, my employer laid me off while I was off on a medical leave. I've been with the company for 8 years. Very disappointed by this. What should I do? Is layoff just a way to fire me? Okay, so it sounds like they placed you on a temporary layoff, Lynn. So the first thing that you need to kind of look at, out of all this, of course, you're on a medical leave, so we'll get to that part. But the first thing is, do you have a contract with the company that permits them to lay you off? And usually this is, of course, a written contract. And so somewhere in that contract that you've signed, there should be a provision that says, the company can, temporarily lay you off, during your employment. So that would be the first thing you kind of need to look at and determine, do I have, such a contract? Is there a written agreement between myself and the employer that allows them to place me on temporary layoff? That's the first thing you need to determine. If there isn't such a provision, and oftentimes there's not, the contractual agreement to lay off an employee on a temporary basis, then just on the outset, the employer, again, presuming that you have no prior history of being laid off, and this is the first time you've been laid off, then for the most part, usually the employer has no legal right to lay you off just to begin with. So there needs to be something in your contract, typically, express, provision, language, something in the agreement that says, we can lay off Lynn, under, pursuant to the Employment Standards Act. If that doesn't exist, then there, probably there's no legal right to lay you off even to begin with, and that could be a constructive termination of your employment right then and there. If you're in a profession where there is a history, or you particularly have a history of being laid off, then it becomes more complicated. As well, again, if the profession is one that layoffs are typical, like seasonal worker, for instance, where the landscaping company only operates from the spring to the fall and doesn't operate in the winter, and every year you're laid off. That could be a particular different instance there, but as long as it's basically not that, and almost unless there's an actual history of you being laid off, and there's no actual legal right in the contract to lay you off, then it would seem to me that this is just on its face already a constructive dismissal. You've already been terminated in effect just by the employer putting you on temporary layoff. You've already been terminated as a result of that. The other issue, kind of to your point, your question here about the medical layoff as well. Well, that could be, again, it's sort of secondary to whether the employer has the right to lay you off. But absolutely, it could certainly go into if the employer doesn't have a legal right to lay you off, i.e., no employment contract, number one, that says you can be laid off, and number two, no history of being laid off, then absent those two things, this decision to put you on a layoff while you were on a medical leave certainly looks very bad in terms of whether the employer may be liable under the Human Rights Code, for instance, if you're a provincially regulated employee, which most people are, they're being liable for human rights damages potentially if the layoff / termination was what it is really is, if that has anything to do with your medical leave of absence, even if it's 1% has something to do with the fact that you're on a medical leave of absence and they made a decision to lay you off. Absolutely, that could expose the employer to further damages under the Human Rights Code. So really, Lynn, to kind of recap, what you should be looking for here first is, number one, do you have a contract you sign with the employer that allows them to lay you off? That's number one. Number two, are there any history here of you being laid off in the past? And if the answer to both of those questions is no, then you've already been constructively terminated, and you should consider reaching out, for instance, to us here at the firm to get an assessment of your severance package, which after 8 years would be quite significant. So you can go to the link that just popped up below there, employmentlawyer.ca, and have a gander there in terms of what steps you should take next and how to get in contact with us. We of course have people standing by all the time to answer and further assess your situation. But it sounds like to me there may be already a termination of your employment here that's occurred just by the fact that the employer has laid you off in these circumstances. So if you have a further question or further clarification, happy to answer that. If you want to add some more details about your situation, we can go through it a little bit further. But yeah, sounds to me like there's some issues here. You can, of course, also access our severance package calculator just to get a sense of, presuming you have been terminated, how much, potentially may you be entitled to in a severance package after 8 years of service in your particular role and position and rate of pay at the company. So you can see the links popped up there below, pocketemploymentlawyer.ca. So go there and you can basically anonymously determine a rough estimate of how much your severance package may be in the circumstances. So thanks, Lynn, for that question. A great question, because it happens all the time that employers who are suffering in some financial respect decide that, okay, well, to ease the burden on us, let's just stop paying this person and put them on a layoff. And for the vast majority of instances that I come across, the employer never actually had the legal right to begin with to put that person on a layoff, and they were constructively terminated as soon as the employer did exactly that. So very great question from you there, Lynn. So thank you for that. Happy to answer anything further on that particular topic. Let's move on to some more questions that are coming through here again this afternoon. Looks like Naisha, I think it is. I hope I'm not mispronouncing your name, from YouTube, has asked, I'm transitioning to owning the business I work for. My coworker is supposed to be joining me as a purchaser, but is not doing the work. If I buy the business solo, how can I protect myself and stop him from leaving and stealing my clients? Okay, so if there's a co-purchaser, I mean, it's a very detailed question, Naisha, that requires a very kind of detailed analysis. But to make it simple, what you would probably want to do if it's a person who's involved with in purchasing a particular business or taking one over, of course you're going to want to have some kind of an agreement between yourself and this individual. For instance, to stop them from stealing the clients that you may have, that would be something along the lines of what's called a non-competition agreement. So something that in great detail lays out how this person, who again is a co-owner, cannot engage in practices that would, for instance, be in a conflict of interest with the business by taking, clients, for instance, from the business and using it for their own benefit. Number one. And then number two, of course, if they leave the business as a co-owner, some kind of regulation or very specific provision that again regulates for a certain time period in a certain geographic area, what can and can they not do with respect to your clients. Non-competition agreement is usually very broad. You may need something as simple as just something to stop them from soliciting your clients after they have left your business there. So that would be a non-solicitation agreement, and basically it would be kind of again outlining for a particular period of time, usually it may be from 6 months to a year, that this person cannot use their information that they obtained while working with you to draw away your clients and solicit, induce your employees, for instance, to come and work for their company. And those kinds of non-solicit agreements are perfectly legal, provided that they're drafted accurately and precisely. And then of course there's also the broader kind of non-competition agreements that may be potentially something you can look into here as well. But certainly you're going to want to have some provision in this agreement that deals with, okay, during my employment, this person cannot engage in conflicts of interest by redirecting to their companies or businesses, people or clients or prospective clients that they come across through, working with me, number one. So no conflicts of interest. And number two, again, a non-solicitation agreement or provisions discussing exactly the fact that, for a certain period of time, this person, after they leave the business, cannot, solicit or induce or attempt to, lead away your clients or employees to come and work for their business. And those kinds of agreements are perfectly legal and perfectly standard, again, provided that they're drafted correctly and accurately. So, definitely this is something where you want to get legal advice on. And of course, you can reach out to us at the firm, and we're happy to provide more detailed and accurate drafting and legal analysis of this particular situation. But certainly this is something where you want the contract to be very clear, to be very precise, so that you are protected if they do leave the business and they may decide to try to take clients from you or take employees from you even after they have left. You want to prevent the person from doing that, and doing so is entirely legal. So absolutely reach out to us there at the link below, employmentlawyer.ca. We have people standing by to assist in that respect. So hopefully that helps. In terms of stopping them from leaving the business, that is much more difficult to do. Generally speaking, there's a right of person to contract with anybody whom they wish to contract with, and so you can't really prevent the person from leaving. There may be potential penalties that the person may forfeit this or that if they leave the business at a certain point in time. But in terms of preventing them from leaving this kind of co-owner situation with you, that unfortunately is not something that you can typically contract for in a legal agreement. The person can leave if they wish to. You can't force them not to. But what you can do, as we've been discussing, is put in language in a contract that ensures that your continuing interest in the business that you're operating now by yourself potentially is not harmed by the fact that this person left. In terms of, again, your clients and your employees and things like that. So definitely something where you'd want quite detailed legal advice and drafting of a particular agreement in those circumstances. So thank you, Nisha. That's a interesting, great question, because typically those are not the kinds of questions that I see here in the 30-minute employment installment, but it's a very interesting one. So thank you for asking it, and certainly reach out to us for further details there. Now that we're getting through this segment, once again, looks like some more questions are trickling in, which is wonderful. Again, if you're just joining us this afternoon, I am Sephton Leibbrandt, an associate at Samfiru Tumarkin LLP, and we are the employment lawyers. So thank you, everybody, again, for joining us here on our regular Q&A. So jumping right ahead here, it looks like Kyle has asked from YouTube, my employer has decided that they want to change our vacation entitlements. How much are they allowed to change this on us? Is there anything we can do to prevent this? So, Kyle, it kind of depends on a number of factors. Number one, knowing how much vacation you have right now would be sort of helpful. The minimum, so you understand, if you're a provincially regulated employee, not a unionized employee, of course, you're privately regulated. So basically, almost any profession that's not, telecommunications or banking or interprovincial transportation, that would be those would be federally regulated employers. If you're anything but that, then, and you're not unionized, of course, then you're a provincially regulated employer. So the ESA, Kyle, provides that for someone who has fewer than 5 years of service, minimum is 2 weeks of paid vacation per year. If you have 5 or more years of service, then the minimum is 3 weeks of paid vacation per year. So obviously, the employer is prevented from ever going below those minimum thresholds in terms of paid vacation. So, but with respect to your vacation entitlements, for instance, if you have 5 weeks or 4 weeks or something along those lines, and they want to reduce it to 3 weeks, the minimum under the ESA, potentially they could do that. It would really depend on how long you've been employed there and how long that's been your arrangement with the company. For instance, if you're a very long-standing employee, 5 to 10 years, for instance, and you have 6 weeks or 5 weeks of vacation every year, or even 4 weeks of vacation every year, and the employer wants to then put that down right to the minimum amount of vacation of 3 weeks, that potentially could be strictly a breach of contract, of course, by the employer, and potentially a constructive dismissal. You really need to demonstrate, Kyle, that there's some kind of material prejudice that you're suffering here. That's my experience with these kinds of things. How exactly, financially are you suffering by the change? Again, if it's, that you have 5 weeks of vacation and you've been employed for 10 plus years, and this has always been the case effectively, of course, with the employer, for instance, and now all of a sudden they're coming and trying to change that to 3 weeks, the minimum under the ESA. Yeah, I mean, I could certainly see how that would be, a very material and potentially prejudicial concern that you may have. If it's, you're losing a week of paid vacation, technically speaking, is it a breach of contract? It may well be, but is it, sufficient enough to demonstrate you're owed a severance package? Probably not on its own. You really need to show, again, that you're losing something material, something significant really to you in terms of money. You're losing money because of this, or you're being harmed because of this change. It's difficult to prevent it if it's the case that it's still legal, above the minimum entitlements prescribed by the Employment Standards Act. So this is really, Kyle, a very contextual situation. We need to know, how long have you been with these folks? How long have you had X amount of vacation? What are they changing it to now? To determine, is there even something enough to go on there that you can demonstrate, this is, a breach of contract, constructive dismissal, and I'm owed a severance package, which is all you probably care about at the end of the day, maybe, or, can you prevent it? Probably not. You can't prevent, the employer from, unfortunately, doing things unless it's strictly illegal to do. But what you can do, of course, is get compensation, money from the employer, typically in terms of a severance package, because the employer has made a significant change. So if you have further, details about this, Kyle, you can certainly put them in the chat. Happy to answer it further, but hopefully that kind of gives you a sense of it here. This is something where you probably want to get further legal advice on, so you can certainly reach out to us there. The link that just popped up below, employmentlawyer.ca, to ask any further questions that you have, or put them in the chat here. Yeah, this one you're probably want to get some legal advice and assessment of your matter to determine whether it even reaches kind of the threshold of a constructive dismissal. It's, again, it really depends on those factors of how long have you been with the employer, and by how much are they hurting you with this change. Is it you're losing a week of paid vacation? If so, then it's unfortunate, but is it enough that you can pursue the employer? Potentially not. If it's 2 weeks plus, that's something different. So thanks, Kyle. If you have further questions, happy to answer those in the few minutes that we have here. If not, moving right along here to another questions that have come into the chat. So it looks like Neil from YouTube has asked, if you are employed under an annual contract, does an employer owe you the full length of that contract if they let you go? If they wait for the contract renewal, then you owe nothing. So yeah, Neil, to answer your questions shortly and succinctly here, if it's a fixed term contract, you're employed for a year, and the employer doesn't have an enforceable, this is where it gets tricky, an enforceable early termination provision in that contract, then, under the law, yes, if you are terminated before the end of that contract, the law says you're owed the balance of the contract. And the great thing is even that if that's the case, you have no obligation to look for other work, which you usually typically do if you're ordinarily terminated in employment, because the court basically says, I hit my computer there. The court basically says that you expected to be employed for the entire duration of that contract, and so the employer owes you the balance of the contract if they terminate you early. And again, this is the important part where you'd want us, for instance, to have a look at your contract here, to determine if there are termination provisions in the agreement, are those enforceable or not? And if they're not enforceable, then you're owed the balance of the contract. If it's not renewed, you're correct that you're not owed anything further under a fixed term contract situation. You don't have, if the contract expires and they don't extend it or anything of that nature, then absolutely, unfortunately, you're not owed anything further. But if you're on a year contract, they terminate you 6 months in, nothing enforceable allows them to do that, then you're owed the remaining 6 months on the contract. No questions asked, simple, super simple. So this is one, again, where you're going to want to reach out to us. You can see the little links pop up below there, employmentlawyer.ca, and we're happy to kind of, have a look at your contract there and see, are you entitled to, a severance package here, for instance, for the balance of the duration of the contract. And kind of, further to your question, which is quite important, if you're on one contract and the contract is extended further, then depending on how long it's extended and things like that, then it could be the case that you're actually not even a fixed term employee, you're actually an indefinite term employee with the company, and things changed a little bit there in those circumstances. So but for the simplicity of your question, you're 100% accurate that if they terminate your employment, nothing illegally that prevents them from doing so during your term there of the fixed term, then you're owed the balance of the contract, plain and simple. So definitely reach out to us, Anil, about that so we can have a further look at your contract there and see, if there are provisions that let them terminate you early, are those legally enforceable? And oftentimes, my experience with most contracts is that they're not enforceable. And I can have legal arguments to get around those provisions and get my client a severance package on that basis. So certainly reach out to us about that. We always have people standing by, of course, to answer any of those kinds of questions. So it looks like we have completed the questions, unless there's anything further from folks for our 30-minute installment here this afternoon. Thank you again, everybody, for joining us. I really appreciate it. If you like what we do here and the information that we provide to you, then absolutely please like and subscribe to our various channels, YouTube, etc. We greatly appreciate it. So our next session, I believe, is going to be with our co-founding and managing partner, Lior Samfiru, tomorrow at 1 p.m. in the afternoon. So please join us again for that session. As always, thanks everybody for tuning in, and enjoy the rest of your day here today.